February then. I just saw you February.
Good morning, everyone. We're glad to have you watching us, whether you're watching us live or watching the video after the fact. Just to let you know, this is being live streamed and recorded, and it is going to be on YouTube, LAER training. This is the first time we've done this course. It's part of the 30-day course that we offered last year, and it's called Selling and Buying 101. What we're going to do is go back to the basics of all of the documents and thoughts that are involved in putting an offer together, putting a listing together, and it's going to be an interactive class. We do have guests coming. We are going to be here for the next 9 days. If you do have any questions during the class, you can type them in and we will get those questions answered. The modules, the PDFs of each class are in Jostle in the library under training. And today's class is about agency and lead paint. And also the PowerPoints are in Jostle in the library under training as well. So even though I haven't made a separate place for the 9 days of training, I've taken them out of that 30-day training. So let's get started, and we will talk about agency in general and the different types of agency. In the PowerPoint, you'll notice that there are also links that you can refer to. The history of brokerage relationships. The fundamentals of agency are unchanged for hundreds of years, but application of agency law and brokerage relationships are constantly changing, actually. Let the master answer. This maxim means that a master is liable in certain cases for the wrongful acts of his servant. So remember that we have a broker of record, Stacy. Remember that we are a designated company. We'll talk more about that. And that we need to remember all the time how we are acting. So in the basic terms, we're going to be talking a lot for the next 9 days about terminology. I think sometimes we take the glossary of terms for granted. We need to understand the meaning of them and also need to be able to explain them to our clients. So it's going to be a good refresher for all of us. An agent is one authorized to represent and to act on behalf of another person, called the principal. The language of real estate, the principal, i.e. the client, buyer, or seller, or real estate broker, broker of record. So the agent is us. The client, also known as the principal, is a person who is represented by an agent. Client relationship equals fiduciary relationship. And we'll get into that later. We'll talk about buyer agency more later on, whether the client is a customer or a client. Customer, the next one, is a buyer or seller who is unrepresented by a real estate licensee. How many of you have written a buyer agency contract in the past?
Me.
Okay, so we will go over that because there's a lot to that and a lot to understand. Designated agency, individual agency. A designated agent is an agent designated to be the agent for a buyer or seller to the exclusion of all other agents in a brokerage real estate firm. We will go over that later on as well. I don't think that's in today's module. But we're going to go over your agency disclosure, and we are a designated company, and that's exactly what it says in the agency disclosure, is that only you, the agent, represents the client, not the entire company, because we are overwhelmingly a designated agency company. Not everyone is. So you'll see those forms filled out differently by different agents that come to work for you. Another salesperson in the firm could be designated the agent of the other party without thereby creating a dual agency for the individual agents. That's a little complicated as well. So again, in bold letters there, the LAER Realty Partners company is a designated agent firm. So you're always on the right-hand side, we'll go over that later, of your agency disclosure, you're always going to put that we are a designated firm, and explain to your client that it is only you representing them, not the 450 agents in our company. Disclose dual agency. Simultaneously representing both the buyer and the seller with the informed consent of both. Again, we will go over this more in detail later on in the week. That definitely disclosure is always important. And let's just take the case of the seller. The seller understanding what that means when you hand him the listing contract and it talks about dual agency. So that you're not springing it on him mid-transaction, that you've gone over it with him at the beginning of the contract, so that he knows that if you get in that situation, that he's already been made aware of what it means. Facilitator is a term that we still have in our documents. Has anyone ever seen someone act as a facilitator? I think it's rarely used. But otherwise known as a transactional broker or salesperson or non-agent. The facilitator works to complete the transaction. Although bound by license, they do not have a fiduciary responsibility with the seller or the buyer. There are extenuating circumstances where this may happen, but it's just not done very often. They do not represent either party in the transaction. The facilitator must disclose all known material defects that exist. Failure to do so could result in a Chapter 93A violation for not disclosing. Their duties consist of accounting and any other facilitator duties undertaken. So it's truly overseeing the transaction being put together without specific representation of a buyer or seller. Principal, we just talked about, is the principal party in the transaction who hires an agent to represent them. Subagency went away in the 90s. I remember when it went away. A lot of people had a lot of difficult time understanding that. But it's an agent of a person who is already acting as an agent of the principal. If that, again, we don't, when you're filling out your MLS listing form, we don't have a subagency anymore. Agent versus broker. While an individual may act in both capacities, and often does, the terms have different meanings. And we all should understand that. You know whether you have a broker's license or a salesperson's license. And sometimes people casually use the comments interchangeably, which they kind of shouldn't. We are going to talk about the Mass Mandatory Licensing and Consumer Disclosure. I have those with me for us to fill out, but we'll do that when we go to do the listings and the offers. When must they be prepared? Anybody want to answer that?
First meeting,
Yeah.
first person, first meeting.
So again, this is where I really I would enjoy going back to us understanding the terminology and the glossary of terms, because again, we're using the scripts to represent ourselves and the understanding of real estate to our clients. And as you know, it's going to be different if you have an investor who's bought 10 properties, or if you have someone buying their very first home. You're going to profile the way you're talking to them, how you're explaining things, how you're answering questions. But you need to represent to them and disclose to them how they're being represented. The way, and again, we'll go over this when we do the forms, the way I always explain signing the agency disclosure is, this is not a contract, but it's a statement of how I'm representing you. So that's an easy way for them to understand it. No matter what relationship is established, the disclosure is to be provided by the licensee immediately at the first personal meeting to discuss a specific property with the prospective buyer or seller. there have been people planted in the past to check on whether we're doing that or not, and people have gotten caught. So it's not anything to take lightly. And we will be filling out a seller's agency disclosure and a buyer's agency disclosure. Another question, the next question here is who can sign the form, who must sign the form? Good question to ask, especially in a listing, with the listing documents, is who are the owners? Are they, and people will ask, are they both going to be present when you sign the listing documents? And it may not just be husband, wife, partner, partner. It could be a trust. It could be parent-child. It could be two relatives. It could be two co-workers. So it's always important to ask, who are the people on the deed? Who are the actual owners of the property? And they are the ones that should sign the document. Again, we'll go over this when we have the forms in front of us. If the consumer declines to sign the form, there is a checkoff at the bottom of the page. I've never had anyone decline to do that. Has anyone experienced that? No. The broker or salesperson is still required to complete the licensee section. So you have to put your license number and your signature in there too. The consumer still must receive a copy of the form they will not sign. And the broker must retain mandatory disclosure form for 3 years. There's a good one for us to remember. And these things do get checked. Mm-hmm. Now, the open house exception. At an open house, the real estate licensee must conspicuously post or provide with other written materials any relationship so that the attendees can understand the relationship. And it was pointed out recently that disclosure statement should be the same size as your other marketing materials that are there. We do have that form in Jostle, and what I've done is framed it in plastic, and I have it on the table where the people sign in, so it's always visible and present. The other terms and definitions. Let's see if this goes forward. Oh, we just did that. I forgot to go forward on my slide. Hang on. Fiduciary is a relationship that implies a position of trust or confidence wherein one person is usually entrusted to hold or manage property or money for the other. The term fiduciary describes the faithful relationship owed by an attorney to a client or by a broker or salesperson to a principal. The fiduciary owes complete allegiance to the client. Language of real estate. Everybody understand that? So that's important, that they understand. I mean, even that makes me think, of course, of Code of Ethics. They need to understand that you have a license, you're taking not only your job and your license seriously, but your relationship with them seriously. Informed consent. Consent to a certain act that is given after a full and fair disclosure of all facts needed to make the consensuous choice. So remember, we'll talk about this a lot more too, that disclosure is really important, and informed consent is another big part of that. Now, see, you wonder why it's hard for us, and then we have to simplify this for the clients. So the next one is vicarious liability. A principal may be responsible for the actions of their agents. Liability created not because of a person's actions, but because of the relationship between the liable person and other parties. For example, a real estate broker is vicariously liable for the acts of his or her salespeople while acting on behalf of the broker, even if the broker did not cause the liability. So we all work under a broker. The broker carries that liability, and boy, that is a serious consideration. So the actions of all of us are held by Stacy, and that should be the little something on our shoulder every day. That and code of ethics again, to help us to be thinking before we act, and to be doing everything very carefully as to the consideration of the liability of the broker. So duties that may be required of licensees. Are we all familiar with old car?
Mm-hmm.
So old car is obedience. The agent must carry out all lawful transactions of the client. Loyalty. An agent must act in the best interest of the client. Disclosure. Agents must disclose all information relevant to the client. Confidentiality. Duty to keep confidential clients' information or discussion. Duty survives termination of agency relationship. That's a very interesting comment. So it's saying if you represented a seller in a transaction and the closing happened, you still have a responsibility to the relationship that you had with that seller of confidentiality. That does not change after the closing. Duty does not apply to legally required disclosures such as known physical hazardous conditions of the property. Boy, I can tell, if you don't mind, I'll tell a great story about that. I had a listing in Carlisle. We'll talk about this more in lead paint later on, but these people had owned the house for 25 years, and he filled out the lead paint form and said it was just a normal lead paint form. He had no knowledge. There is a website in Massachusetts where you can go check the history of lead paint. Before they bought the house, it was owned by a, let's say, a foreclosure company, and there had been evidence of lead paint, and it had been remedied. All this prior to that owner knowing it. So did the owner fill out the lead paint form improperly? No, because he stated what he had knowledge of. Mm-hmm. And he never knew that the foreclosure company had found anything or had remedied anything before that. But the buyer, in that case, because there was a history, they informed us that they had found that in that website, and they wanted a complete lead paint test done, and our seller agreed to it. So it wasn't a fault of anybody. They had truthfully filled out the lead paint form. This sometimes happens as well when you have, let's say you have a history of a house that is 30 or 40 years old and it's had 4 or 5 owners. The present owner can only fill out the form to the best of his knowledge. Mm-hmm. It's different in a multifamily where there's been an official de-letting done and there's reports on record. That's a different thing. But when you have owner going on and on and on, that's hard, because you only have the knowledge of the present person that's living there. Accountability. The agent must protect and account for all monies, documents, and other personal property given to her by the client. Again, we have a really good system in place for accountability of money, and the money should be given and recorded and deposited same day, almost immediately, if we can, that's for sure. Reasonable care and due diligence. Reasonable care, and agent must act competently, capable of performing duties within the scope of license requirements. Anybody have an understanding of that? That's a hard one. It means that you're only liable for what you understand and have knowledge of. You're not an inspector. If they have questions about things that are superfluous to the transaction, you could say to them, Google it or go look on the town website or things like that. It's not something that you're an expert of, that you should have the knowledge of. So let's talk about types of brokerages. If I can get this. Note, standalone continuing education courses are offered for seller and buyer agency and facilitation to provide further detailed reference on the responsibilities of these roles. Seller agency, which again, just isn't happening anymore. Real estate agent represents the seller. I didn't mean to say that, but that's subject. Anyway, we'll talk about that in a minute. Real estate agent represents the seller as the client and treats the buyer as a customer. Agent's duties to the seller client include old car, all of those things. So you are representing the seller. Seller sub-agency. When the seller client expressly authorizes his or her agent to use other agents to market the seller's property, the sub-agent's duty to the seller includes old car. Specific legal requirements to offer sub-agency to cooperating brokers are: written informed consent must be obtained from the seller client to offer sub-agency, and consent must state the following: that the broker may cooperate with another broker who is then a sub-agent to the seller. Further, that vicarious liability is a potential for a seller to be held liable for misrepresentation or an act or omission of the sub-agent, and that the seller authorizes the broker to offer sub-agency. Okay, really complicated, right?
Very.
So, I mean, you clearly need to know who you're representing. You clearly need to have the confidentiality and loyalty to that person that you're representing. And it actually makes you sound like you really know what you're doing by stating that to your seller, especially because sometimes they don't understand all that's involved in what our license and code of ethics represents. I keep going back to code of ethics. We're going to talk about that one of the days that we're here as well. Buyer agency. Real estate agent represents the buyer as a client in a real estate transaction. Agency's duties to the buyer include old car. Buyer sub-agency, not commonly used. Only when the buyer client expressly authorizes his broker to use other agents to assist the buyer in locating a property. Again, that's not commonly done. Facilitator, we just talked about that. A facilitator exists. They're really, it's not that they're a transaction management person, but that's kind of what they're doing. They're not representing either the buyer or the seller. They're following the transaction through. They are not an agent. They are bound by license law, but they do not have a fiduciary relationship with the seller or buyer. They do not represent either party in the transaction. The facilitator must disclose all known material defects that exist. Failure to do so could result in a Chapter 93 violation. So again, facilitator is very rarely used. I don't think I've ever had anyone present an offer to me that was a facilitator. So, dual agency. A real estate licensee who represents both the seller and buyer in the same transaction is a disclosed dual agent. Remember, we talked about explaining this to your seller when you list the property, and we'll go over that when we do the listing contract. Written informed consent of both the buyer and the seller, see below. Fiduciary duties are owed to both buyer and seller. Undisclosed dual agency is illegal, meaning that the disclosure is what is important to do first. A dual agent assists the seller and buyer in the transaction, but shall be neutral with regard to any conflicting interest of the seller and the buyer. Consent may be obtained in the listing agreement, buyer-agent agreement, or in the standalone consent form. If consent is obtained prior to the identification of the transaction, then notice of dual agency must be provided. So again, we'll talk about that when we do the listing. If you do the listing contract that includes dual agency, that would be done. If you, at a later point in the transaction, become a dual agent, then you need to fill out that separate form and disclose that to both parties. And it must be provided prior to the execution of the offer. You have to make sure they understand the role that you are playing. Sample form is available. I think I actually brought one with me. And the duties of the disclosed dual agent include only CAR, C-A-R. Let's go back and look at that for a second, of the old CAR. So it only includes confidentiality, accountability, and reasonable care and due diligence. Written consent form must state a real estate broker or salesperson may act as a dual agent who represents both prospective buyer and seller with their informed written consent. A dual agent is authorized to assist the buyer and seller in a transaction, but shall remain neutral. Consequently, a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, and reasonable care to lawful instructions, but shall still owe the duty of confidentiality of material information and duty to account for funds. That's pretty clear, I think. Buyers and sellers should understand that material information received from either client that is confidential may not be disclosed by the dual agent except if the disclosure is expressly authorized, is required by law, is intended to prevent illegal conduct, or is necessary to prosecute a claim against a person. So let's hope none of that ever happens, but just, be aware of it. It's that serious. And when you get into dual agency, it is a little complicated. That's why disclosure of it up front is really important. This duty of confidentiality shall continue after termination of the broker relationship. Again, just like we discussed before. Notice form must provide, when consent to the dual agency has been given in advance of the identification of the potential transaction, written notice of dual agency must also be given by the salesperson to the seller or prospective buyer after the transaction has been identified, meaning after the particular property, that the broker is a dual agent with regard to the transaction. So written notice, again, consent forms must be signed. The process for dual agency should always be disclosure, consent, and notice if applicable. Again, if it hasn't been stated in the listing contract, then you would have to do that separately. Important notes about designated agency. And again, LAER is a designated agency firm. Designated sellers. The designated seller agent will represent the seller and will owe the seller the duties of loyalty, full disclosure, confidentiality, to account for funds, reasonable care, and obedience with lawful instruction. All other licensees affiliated with the appointing broker will not represent the seller, nor will they owe the other duties specified in the paragraphs to that seller, and may potentially represent the buyer. So in a way, that's easier. With us being a designated agency, I could list the place and one of you could sell it, and it's two separate things because only I am the designated agent for the seller. So it just makes it much clearer. If designated agents affiliated with the same broker represent seller and buyer, the appointed broker shall be the dual agent and neutral as to any conflicting interests of the seller and buyer, but will continue to owe the seller and buyer the duties of confidentiality of material information and to account for funds. So the broker still has overriding responsibility. Designated buyers. The designated buyer's agent will represent the buyer and will owe the buyer the duties of loyalty, full disclosure, confidentiality, accountability of funds, reasonable care, and obedience to lawful instructions. All other licensees will not represent the buyer, nor will have the other duties. So that again, the designated makes it a little bit clearer. If designated agents affiliated with the same broker represent the seller and buyer, The appointing broker shall be a dual agent and neutral to any conflicting interests, as we just said. So if in fact a legal issue arises, policy and legal issues for designated agent practice. Agents must be extra diligent about keeping buyer and seller files and documentations confidential. Keeping it is the first thing.
Yeah.
Keeping it.
Keeping it.
Wherever you keep everything, keep it. Even if in your Gmail or whatever it is, you archive it, it's still there. It may not be in the forefront, but you've kept it. How many of you use Dropbox or Google Docs? I mean, I use Dropbox for everything, and I have a file for each transaction. It's really important. Even though we have the stuff in .loop, I just, I'm always thinking of keeping every communication that there is, just in case. When using common area computers, always close out or delete personal files. That's another thing. Be aware that when you have an offer, I'm sure we've all seen it. Be very careful. If you print an offer out at the office or something, pick it up right away. There have been times when I've seen offers left and the people have left the building and the terms of the offer are sitting right there. And that's not right for any of us to be seeing. Never leave files or paperwork in the copy machine or copy areas. We just discussed that. When discussing real estate transactions by phone, make sure you are in a private area. Discussing, remember who you're loyal to. I have to say, I've heard people discussing what offers are, what the seller will take. None of that is proper. It just is not. And you have to be careful not to say that or who you're saying it to, because you never know who's watching or who the people are planted to catch us in doing the wrong thing. And we should always be conscious of that. Designated agency must start with the correct disclosure references above. The privacy is really important, and that's why we've worked so hard to get .loop in place and used not only primarily but thoroughly, so that you have the complete transaction there. Conflict of interest. The designated real estate broker exclusively represents the seller or buyer and is responsible for the performance of any duties owed. The designated broker or salesman may not share known or acquired information with any other real estate agent or person that would harm the seller or buyer's interest in the real estate transaction. It's a sorry thing to say, but in the past I've heard somebody say, gee, we just put that under for such and such or whatever it is. And what if that deal goes south and then it's back on the market again, and then what the seller accepted? I mean, you've got to always be conscious of the privacy of that. Setting compensation among competitors is a violation of antitrust laws. That's another part of it. All brokers and salespeople are encouraged to take a full module on agency in conjunction with this course to further enhance their knowledge and professional practice. Here are some required handouts, and again, we're going to go over all of those, and I actually think they're right in here. So let's flip the page to the next page. Does anyone here have their New Hampshire license?
What?
New Hampshire? No. Okay, so this is the Massachusetts form. You've all filled one of these out?
Mm-hmm. Mm-hmm. No.
Okay. So this again, remember in the beginning I said this is a statement, not a contract, which is true. So this is the Massachusetts Mandatory Real Estate License Consumer Relationship Disclosure. What does it say right underneath it? This is not a contract. So that's why I always say that to people. And I say to them in that first meeting, I need to state to you and to the world how I am representing you. Am I representing you as a buyer agent? This has nothing to do with buyer agency contract. This has to do with purely if there are a buyer or a seller. This would be part of your listing documents, which we'll go over later in the week. but you need to state who you're representing. And when they hear that, then they get the clue. They're like, oh, you're on my side. You know, whether it's buyer or seller, they at least know, okay, you're bringing me to look at houses and then write up the offer for me. You are the buyer agent.
Yes.
Or in listing the home, okay, you are the seller's agent because you are listing the home, so you are representing me. So if you go to, it says the seller or buyer receiving this disclosure is hereby advised that the real estate licensee named below is working as a. So you really have three choices. Again, I said facilitator is hardly ever used, but you're either going to be representing the seller or the buyer. So you're going to check one off. And then it says if the seller or buyer's agent is checked above, the real estate licensee must complete the following. So what you're going, and you can fill these in right now if you want to. So pretend that you're the seller's agent, check that off. Then where on the right hand side it says designated agency, always check that.
Got it.
And underneath that, so what we did in this example is we did seller's agent, all right? So underneath that it says only the licensee named herein represents the seller. Okay? And you would reverse it if you were doing buyer. But again, as we just learned in those illustrations, it makes it so much simpler for them to understand. They don't need to understand all that's involved with our licensing and Stacy as our broker of record, but they see it clearly that you are the person that is representing them. So now below that, again, you can do all of this right in dot loop, and we're going to go over dot loop in great detail next Monday. So where it says signature of licensee, you're going to signature your name. You know, signature, go ahead, fill that in, signature your name. And then next to it, you're actually going to print your name. And again, you can do both of these things in dot loop. All right?
Yep.
Then next to it, you're going to put your license number,
Right.
which you should all have memorized.
Yeah.
Here's a question.
Yes.
Okay, I have my broker license now,
Yep.
but I'm acting as an agent. So am I a broker on this or am I an agent? Like I'm technically a broker.
I'll answer that the way I feel comfortable. You do a broker's license. A ton of people have broker's licenses here, which is fine, and you'll see
Right.
that in 1 second. Stacy's the broker of record,
Right.
but you have a broker's license,
Right.
which is
Yeah.
one step up. So to the right of license number, see where it
Mhm.
says broker?
Yeah.
Your license number represents
Says
that you
broker.
have a broker's license. So I would check
So
broker
those-
in your
okay.
case.
Okay.
If those of us that don't have broker's licenses have salesperson's licenses, that's what you're going to check.
Okay.
Now, how many of you have filled one of these out in dot loop?
I did.
Okay. When you click on your signature, your automatic signature that comes out, the date is already going to come out right next to
Right.
where your signature is.
Yeah.
So if you're doing all of this in dot loop ahead of time, like preparing for a listing, you won't have to put the date in where it says date here. So then, the other part, I think our stuff comes out naturally.
It's filled in
I
already.
think so.
probably.
So it would be LAER Realty Partners, and our license number is 8890, I think.
What is it, 890?
8890,
8,
I'm pretty sure.
9,
But I think that automatically comes out.
Okay.
Now, the next two things, again, you could be sending all of this to your clients in dot loop, which I hope you are. But remember what I said in the beginning about asking your clients whose name is on the deed. Who are the responsible people for owning this property? And again, it could be husband and wife, it could be two partners, it could be two co-workers, it could be mother and son. So many different situations. But you need to know whose name is on the deed. Not on the mortgage, but on the deed. And those are the two parties that should sign. They're going to sign exactly the same way. And again, that can automatically come out in dot loop. that their signature will fill in, it'll print their name, and they'll put down that they, in this case, we did it as seller, so we're gonna check seller. Now, if you're sending this to them in dot loop, you can do all of that ahead of time. You can put Joe Smith sign here, and you could check off seller, so he knows that he has to do that. Okay? Now, when you hand them this form or send them this form in dot loop, it's a 2-page form. Because, again, it's important for them to receive this full document and understand. Why do you have green stuff there?
No, I just.
Oh, you went further.
Sorry.
So the second page of this explains what a seller's agent does, what a dual, all of these things that we've just gone over. That's a good reference for them to have, and protects you by giving this to them at the first meeting.
Should there be 3 copies? One for you, one for the office, and one for them?
Well, again, copies, remember, we're trying not to do any paper.
You want this all on document?
Oh, absolutely.
So
If for some reason you have to, well, we could talk about that Monday. We can do an in-person.
Okay, we'll do that later.
No. We'll get to how you can bring them in the office. But if you were physically meeting them and having them sign pieces of paper,
Right.
yes, they would always keep a copy of everything that they signed, or you would provide them with that, yes. And then you could take those documents and either scan them yourself or have the admin scan them so that they go into dot loop.
Oh, good. Okay, got it.
Yep.
Okay, that's fair.
The next couple of pages are the New Hampshire forms, which we'll skip over. I shouldn't say that we'll skip over. It's a little bit simpler in Massachusetts. I mean, in New Hampshire, sorry. The next thing that I have on here is the dual agency form. Now, when we get into the listing paperwork, you will notice that the listing document that we use includes dual agency. But again, remember we just talked about if you're doing a consent to dual agency after the transaction has started, then you can fill this form out instead. And this form obviously is in dot loop. A real estate agent may act as a dual agent who represents both the prospective buyer and seller with their informed written consent. A dual agent is authorized to assist the buyer and seller in the transaction, but shall be neutral with regard to any conflicting interest of the buyer and seller. Consequently, a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, reasonable care. So you have to act carefully in this transaction. So where it talks about the acknowledgement, I acknowledge and agree that, and you put your own name in there, is authorized to represent both the buyer and seller as dual agent. I hereby consent to dual agency. Now, in the case that you have 2 sellers and you have 2 buyers, you can, in dot loop, you can put them underneath each other. It depends on how you enter them, but you can do that. And then at the bottom it says the broker acknowledgement, salesperson acknowledgement. I acknowledge and agree to represent the above named consumer as a dual agent, and my signature below signifies that I understand the duties and responsibilities of that relationship and explain them to the consumer, that I am a dual agent and therefore will assist. Especially if you are, I shouldn't really use the word especially, I suppose, but if you had listed a house and then become a dual agent, having the first person understand that you still have old car to him, they sometimes it's hard for them to understand all of that. But okay, enough said about that. Oh, New Hampshire's next. We're going to go by that. As I said, the New Hampshire one is a little bit simpler. We're now going to go on to the lead paint laws. And how many of you have filled out a lead paint form with your buyer?
Oh, with my buyer.
Or with anybody? Have you filled out a lead paint form yet?
Yeah.
Awesome. For those of you that are watching, these forms obviously are in Jostle, but I think the entire form is here in this PowerPoint, which again is in Jostle in the library under training. But we are going to go over that right now. But first, we are going to. Oh, I'm sorry. I had it in my hand to set down. We are going to listen to Stacy's new explanation of this. What you are about to watch is a module that's in LAER University. So again, you're going to go to Jostle, Library, then you're going to go to LAER University. There are a ton of modules in LAER University, and this one, I don't remember the title of it. I think it was called, maybe we'll see it when I get back there. Hang on one second. Rules, Regulations, and Laws, but it's really Lead Paint 101. So this is about filling out, this is about understanding the lead paint law, filling it out accurately, and submitting it accurately. You're going to be able to, okay. Okay, you ready, guys? Yeah.
I'm ready.
Thank you for joining me today for Lead Paint 101, what you need to know to protect your clients and avoid fines on real estate sales or purchases. Overriding policy of the lead paint law is to encourage full disclosure of all lead paint related issues, and it conspires the opportunity to test for lead paint before they purchase a home with lead paint. Unlike rental properties, however, there is no obligation on the seller to actually de-lead prior to a private sale. But common sense dictates that a lead-free house may be more valuable and marketable, and this is particularly true for multifamily properties where tenants with children under 6 years of age may in any event trigger the de-lead requirements of the law. Sellers and real estate agents that do not meet the requirements of the lead paint law can face a civil penalty of up to $1,000 under state law in Mass, and a civil penalty of up to $10,000 and possible criminal sanctions under federal law for each violation. In addition, a real estate agent who does not meet requirements may be liable under the Massachusetts Consumer Protection Act, which provides up to triple damages. By the way, under federal law, the penalty also includes the loss of a real estate license. Who needs to sign? Whenever an owner of a home built before 1978 sells, the listing agent must provide, number one, a property transfer notification certification, and number two, all 10 pages of the Department of Public Health Childhood Lead Poisoning Prevention CLPP property transfer notification disclosure. Most agents only use 1 page of the form, and that is a no-no. You must provide all 10 pages of the Childhood Lead Poisoning Prevention Program. By the way, most of what we're covering today is for a purchase or sale of real estate. The law also applies to rentals, and for rentals, there is a specific version of the property transfer notification certification and the Childhood Lead Poisoning Prevention Program form. So whether it is a rental or a purchase, if a home is built before 1978, the form must be signed by all parties. Can the buyer sign a lead paint first? No, it is invalid. The property transfer notification certification must be completed and signed by the seller before the buyer can sign it. The buyer's signature acknowledges that they are in receipt of the disclosure. Thus, the buyer cannot be in receipt of the disclosure until the seller first completes the form. So when you are first meeting a client as a buyer's agent, it's a great idea to still give the 10-page CLPP form to your buyer so they understand the lead law, because what the lead law says is if there's a child under 6 living in the property, that by law they're supposed to de-lead it if they're buying the property. So it's a good idea to give that 10-page form to your buyer at your first or initial consultation, but you should not have the certification signed by your buyer until there is a property they're buying and the seller has filled out the form first. What has to be filled out? All disclosures and acknowledgements have to be accurately completed, including the seller's disclosure, the purchaser or lessee purchaser's acknowledgement, and the agent's acknowledgement. Agents should be aware that HUD and the EPA have audited brokers' files in the past and have at times found them deficient from a compliance standpoint. Thus, it is absolutely critical to accurately fill out the form. Make sure that the property transfer form, the signature page, has at the bottom of the page a request for the property address, a line for the property address. If it does not, you are using an outdated version of the form. Does lead paint need to be signed if the house is built in 1978 or later? No. The lead paint law only applies to homes built before 1978. Therefore, testing for lead-based paint is not required. If the listing agent provides a property transfer form for a home built on or after 1978, neither the buyer nor the buyer's agent has to sign the form. Can we refuse to let a buyer test for lead paint? No. A property owner or real estate agent cannot sidestep the lead paint law by refusing to sell or rent to families with young children. The purpose of the lead paint law is to protect the health of children and pregnant women. An owner cannot refuse to sell or refuse to renew the lease of a pregnant woman or a family with young children just because a property may contain lead hazards and they do not want to spend the money to remove. Any of these acts is a violation of the lead law, the Consumer Protection Act, and various Massachusetts anti-discrimination statutes that can have serious penalties for property owners, real estate, or real estate agents. Now, that is not to say that your seller would be required to de-lead a property. The issue that comes up here is that any potential buyer has an absolute right under federal and state law to perform lead paint tests prior to becoming obligated under a sales contract. But can the seller legally instruct the listing potential buyers to waive this right or they'll reject an offer? No, because any instructions along these lines would potentially give rise to a fair housing violation for discriminatory practices against families with children under the age of 6 and lead to liability on behalf of both the seller and listing broker for participating in discriminatory behavior. The issue that arises is that we cannot decline an offer simply because somebody is asked to test a property for lead paint. That being said, if the lead paint testing does take place, number one, at that point your seller may now have knowledge that the property has lead paint, and also the lead paint tester may report it to the state, in which case that the seller may have to fix the lead paint issues if they continue to own the property. Let's say that the buyer requests to do a lead paint test and is determined that the property has lead paint. That does not mean that the seller must do all the repairs for the buyer. Just like any other item that a buyer may request, any work done on a property or painting or replacement of anything, the seller can decline to do the work. They are not required to sell the property de-leaded, but they cannot decline an offer simply because a buyer has requested to do the lead paint test. When should the lead paint transfer notification be signed? Although Massachusetts law states that the completed property transfer lead paint notification form must be acknowledged by all parties prior to the signing of the purchase and sales agreement, the notification form must actually be signed by both parties prior to the acceptance of any offer. In instances where an offer to purchase residential real estate is utilized, because that offer is a binding contract for the sale of the property, and the purchase and sale agreement is simply a reiteration of the terms of the offer with other terms and conditions for performance thereunder. The law allows the buyer 10 days in which to have a lead inspection performed. If lead is discovered, the buyer may withdraw from the sales transaction. So in essence, that lead paint form needs to be completed prior to the offer. This is what that 10-page form looks like. If built before 1978, buyers, sellers, renters should get all 10 pages of the property transfer notification. This is that childhood lead poisoning prevention program property transfer lead paint notification, that CLPP, the 10 pages that come before that signature page. This 10 pages should be given to every buyer and seller for properties built prior to 1978. Again, if you are working with a buyer, you should never have the buyer sign the actual certification until you have it filled out by the seller. But I think it's a great idea to always give the 10 pages, the 10-page form to your buyer well in advance of buying a property, so they understand what the law is if they end up buying a property that was built before 1978. Here's the actual property transfer notification. We're going to break it down into segments to make sure you're getting these filled out correctly by your buyers and sellers. The first section is just the required federal lead warning statement. It lets people know that this form needs to be signed by the prospective purchaser before signing a purchase and sale agreement or a memorandum of agreement, or by the lessee prospective purchaser before signing a lease with an option to purchase for residential property built before 1978, or for compliance with federal and Massachusetts lead-based paint disclosure requirements. Please note that New Hampshire has its own version, but very similar, same form. New Hampshire has its own version as well. If you're working with a landlord-tenant, there's a third version of that, of the property transfer notification certification. It then goes on to explain the warning. It says every purchaser of any interest in residential property in which a residential dwelling was built before 1978 is notified that such property may present exposure to lead from lead-based paint that may place young children at risk of developing lead poisoning. Lead poisoning in young children may produce permanent neurological damage, including learning disabilities, reduced intelligence quotient, behavioral problems, and impaired memory. Lead poisoning also poses a particular risk to pregnant women. The seller of any interest in residential real property is required to provide the buyer with any information on lead-based paint hazards from risk assessments or inspections in the seller's possession and notify the buyer of any known lead-based paint hazards. A risk assessment or inspection for a possible lead-based paint hazard is recommended prior to purchase. The next section of the form is the seller's disclosure. Again, the seller must always complete the form before the buyer can complete the form. Warning here, always remember that there needs to be a box checked off in section A and a box checked off in section B at all times. One of the boxes in A and one of the boxes in B must always be checked off by the seller. It is not either A or B. It is always A and B, and there are multiple options under A and B, but always one box in A and one box in B must always be checked off. Too often, sellers will check off the no knowledge. They have no knowledge of lead-based paint under section A, but then they don't check off anything in section B, which is not correct. All sellers need to complete the form. Next, the purchaser section. Let's dissect the purchaser section to make sure that your buyers are initialing and checking off all the right areas. Please note that either C or D must always be initialed. So on every form, either C or D must always be initialed, not checked off by your buyer. Also, E must always be initialed. This is the disclosure. It says the buyer has received the property transfer lead paint notification. That must always be initialed. F must always be initialed. So C or D must always be initialed. E must always be initialed. F must always be initialed. Then let's go down to F1 or 2. F1 or F2 must always be initialed. Too often, agents are checking off F1 or F2, but they're not having the entire top section completely initialed by their buyers. And remember, all buyers. So just like under all sellers, if you have 3 sellers, then all 3 sellers need to check off and sign the form. If you have 3 buyers, all 3 buyers must initial, must sign, and must check off the boxes. Next section is agent acknowledgement. All agents involved in the transaction must initial, not check this section. So, if as a buyer agent, you receive the lead paint notification from the listing agent and there are pieces not correctly filled out from the seller side, you should be kicking the form back to the listing agent saying it's not properly filled out. I'm trying to protect your seller, my buyer, and our real estate licenses. We need to have it properly filled out by the seller. Then all agents involved in the transaction must initial, not check off, the agent acknowledgement section. Next is the signature section. All buyers and all sellers, all agents must sign and date the form. Last, I mentioned this earlier, at the bottom of the form, it's going to ask for a property address. Make sure the property address is filled out completely, and if your form is not asking for the address, then you are working off of an outdated form. Thank you for joining me today, and thank you for protecting your buyers, sellers, renters, and landlords, and our brokerage and your license by making sure your lead paints are properly completed. Thanks for joining me.
I always have a question about this.
Sure.
Okay. How a lot of houses we sell now are built after 1978.
Right.
And they still do the lead paint. Like I've never heard someone say I'm not
So,
doing the lead paint.
You know, again, as you experience each transaction, you'll realize that some offices are trained better than others, and some agents are never trained on lead paint. So, if they don't understand the law, I mean, Stacy obviously was passionate about this, and
Yeah.
we've been very strict to instruct the admins to check all of our documents, and they're going to be thrown back at you. And it's too bad that, to answer your question even more, it's too bad that if we see one improperly filled out by an agent from another company, that we have to send it back to them and police them and say, you didn't do this right. Because it's like us babysitting, but the form has to be filled out completely so that the records that are kept are complete and accurate. I have tons of comments to make. Anybody else have
So on
questions?
every house you fill them out, whether it's built after 1978 or not. That's
No.
what I'm saying.
No,
No,
she
you
said
don't.
no.
No, she did say no. I know, but I've run into some
No.
agents. Some say I'm
You don't
a buyer,
have to, she said in that,
and the seller has it.
no,
and they
you don't
still
have
want
to
us.
acknowledge it.
No. Okay.
That's what she's saying, no.
Okay.
And if they have a hard time with it, they can call Stacy.
Yep.
It was interesting, couple of things that she said to do it as of the offer. So let's speak about that for a minute. And again, we're going to go over this more. We're going to give you a lot of good insights and tricks of the trade of dot loop. Are we fine? We're on? Okay. So one of the things that I'm going to make some comments about dot loop and about MLS pin. Sorry, I'm going to jump around a little bit. But one of the things that Stacy said was having all 10 pages, the complete document. Now, when you pull this document into dot loop, let's say you're preparing the listing documents, the entire 10-page thing will be there, but all you're going to have him fill out is this page. But when you send it to him through the cloud and he sends it back, he will have signed the last page of the 10-page document. So it is all there as the 10-page document. The important next step is that when you go live in MLS, that 10-page document has to be in the paperclip on your listing in MLS. Not just this. And that was what Stacy was alluding to, is that a lot of people do that. It's not right. Now, I'm going to give you a little bit of a tidbit.
I used to do that.
Don't freak out. Wait a minute.
Okay.
So, Kristen Weekly was having a problem with MLS PIN recently because she lives on her iPhone. She's always on the road. When she was pulling up listings in MLS on her iPhone, she couldn't find the paper clips. When you pull up MLS PIN on your iPhone, you're going to have 5 or 6 choices of the names, whether you're doing a full or a customer or whatever it is. I think it's the full some photo summary brief, I think is what it is. But it's wrong. It's not wrong, but I want to speak to MLS PIN about why can't it be in all of them? Why should you have to search in one of the 6 ways? But anyway, if you pull it up in that, you'll find all the paper clips. To that point, there's a reason why I'm saying that. So Stacy was saying that it needs to be signed before the offer. So when I don't care if you're on the road in Starbucks or whatever, if you're going to write an offer on the property, or to go backwards, if you're preparing to show 4 houses on Saturday, you should go into the paperclip and see what documents are attached. Is the seller disclosure there? Are there floor plans, whatever, plot plan, whatever it is? But if the lead paint is there, what Stacy's saying is that needs to be signed at that time and presented with the offer. And I don't think a lot of us are doing it that way.
I do that.
Now, to go backwards, I'll get to your question in a minute. To go backwards, exactly what she was saying is absolutely true, that your buyer should be acknowledging what the seller said. Now, here's an odd example. You know how you can go into Jostle and we have a discussion section? So a month or so ago, one of our agents was writing an offer on a for sale by owner. So she started a discussion. It was a great subject. And she said, do I still need a lead paint? So I chimed in and I said, yes, you do. But I should make you all guess, but I'll just tell you. So what she needed to do, was she representing the seller? No, she was representing the buyer. But she needed to hand him a blank lead paint, have him fill in that top section, because your buyer doesn't sign anything except the acknowledgement of what the seller has said. So that was the answer for her to do that. All right, I'll break. What was your question?
No, I'm not.
Oh, okay. So that's why if the lead paint is there, that would be signed and that would be part of your offer. We'll go over all that is included in an offer. But remember to always look at the paperclip in MLS to see how little or how much a broker has put in there. Now, to go on to talk about dot loop, this is really tricky, and we'll talk about this more on Monday. We have somebody coming in to help us.
Oh, good.
One of the problems that I've had and everyone else has had with dot loop is trying to fit all of those initials into this space here.
The box really small.
There is a way, if you, we'll show you Monday, there's a way if you put your cursor on the bottom right hand corner of the box, you can make it bigger or smaller. The thing that made me cringe in Stacy's video was when she talked about 3 owners. And yes, there could be 3 owners. Boy, does that muddy up the works. Because when you're trying to fit in the initials in those boxes, you don't want the initials to go on top of the wording. And yet you may have to go to the left of where it says C, D, E, and F if you have a third person. It's not that often that you have a third person involved. But your admins are very good at dot loop and can help you with that if you're having problems with that. And it was the same that she said about the bottom of the page, the signatures. Remember what we said about who's involved, how many people are on the deed. So you have to make sure that all the sellers involved in the transaction are signing. All of the buyers involved in the transaction are signing. And it is really important. We've had a lot of lead paint submitted without the address, and that was why she mentioned that that's very important as well. Always, again, going back to acting as the listing agent and to what you asked before, the listing agent will get copies of everything that he has signed, and it should include all 10 pages.
All 10. Okay.
Yeah.
Can I ask you another what if?
Sure.
Because it's going to be my what if soon.
Sure.
So I'm going to have a house listed that was built in, I think, like 1928 or something, completely gutted out and redone though. lead paint.
Oh, we just had this come up in a class too.
The shell's there, but nothing left of the shell. It's just,
So how do you know that the basic studs don't have lead paint on them?
well, they're just bare. And some of them are replaced, right, so I should still do it, just for, yeah, cause it's sided also, so it could be underneath.
Is this a
there.
multifamily?
No, single.
Oh.
I think I would just do it to cover
CYA?
Cover yourself,
Mhm.
yeah. You know, because you never know.
Well, then that's a good question. You know, what was the requirement of the general contractor who led the project to do that or not, or of the owner? I don't know. That's a
What, to gut it out, you mean?
no. To check for lead paint when they were doing it. Like
Oh,
if
well, it's a single family, so he didn't, so. But I'm saying,
so, if there, let's say it was a 1920s house and there was lead paint.
Mhm.
So a potential buyer, you're going to put in MLS built in 1920.
The buyer's gonna look at that and
The
go,
buyer
"Oh,
could
freak,
say,
I have a child.
okay,
I'm not
you've
pregnant."
taken it down
Having a
to the
baby.
guts. How was the lead paint taken out, if there was any? Was it properly, you know,
Oh,
did
yeah.
men in white suits come and take
Yeah.
that out?
no, there
And
was none.
How do you know that?
Well, technically, I guess we don't, right?
Right.
Yeah.
So, I don't mean to oversimplify it, but a lot of the lead paint that was used in older homes
Mhm.
was in the trim work, especially around the
Right.
windows.
Yeah, right.
That's right.
Problem comes in, sometimes people have replaced the windows and not replaced the sills,
Yeah.
which is
We'll replace some
cuckoo.
windows and not
I
all of them.
know.
Yeah, so, all
Would there
right,
be anything on the website
They're
that
gonna
you're
sign lead
referring to
paint,
earlier?
just in
For
case.
his-
Lead paint.
The
I
history
would,
of that?
would
legally,
too.
you're
Oh,
better off that
and
way,
there-
this way they can't
There
come back
might
to
be,
you.
hi. Can you answer a question for us? Come on in and be a guest
How are you
question
guys?
answer.
What question? do you have?
If you had a house that was single family, built in 1920, and you took it down to the studs and rebuilt it, what would you do for a lead paint form? And if there was lead paint in the old parts, was it taken out properly? I mean, who knows?
I think you would have to get an inspection done and get it certified that nothing's there.
Or just do the lead paint.
Yeah, just say unknown.
That's what I would do.
But
do
if they
that
see that it
anyways.
was built in 1920, they're going to question it, right?
Well, they'll question it regardless, so
Sure they will.
just
Right,
say
'cause
unknown.
You can tell it's an older house, right?
Yeah, unknown.
Just, yeah.
I know. Gotta like it.
Okay.
Super. Have a nice day.
You too. Bye. Learn it lots.
The difference comes in multifamilies and tenants.
Right.
That's a different thing. We had an instance recently where someone, I don't even know if it was in our company or not, but somebody had listed a house, and the owner of the multifamily insisted that he had had the home professionally de-leaded. So the agent listed it that way. Yes, this home has
With
been
no documents.
professionally de-leaded. And he promised her through the entire transaction that he would get the paperwork the day of the closing came, and
Oh my God.
he never provided it.
Wow.
So it became a real issue at the
Oh, yeah.
closing. Yeah,
Oh, yeah.
I don't remember what the end of the story was,
Oh,
but
Oh.
You know,
Some
they-
big fines, I would think.
yeah, they could promise you the world, and
Yeah.
man, if it doesn't happen. Um,
Wow.
Again, you want to, when you're helping this is a little bit harder to do, I think, if you're doing this I don't think so. In the agent acknowledgement, again, in the first part, you're initialing that you have informed the seller that beyond what he's stated, the buyer still has a right to have it tested as part of their home inspection.
Right.
And then the other agent is going to, if you're representing the buyer, the B part would be, agent has informed the buyer that they have a right to have it tested. So it's a very complete form, and unfortunately, the history of it is that we have not been completing it, and there's a lot of penalties for that, and none of us have any time for those penalties. So let's skip over to page 28. So tenant-led law notification. I mean, anybody who's a landlord should understand how strict the laws are in Massachusetts. I think they're probably some of the strictest in the country, especially for protecting tenants' rights. So they should understand, if they're a landlord, I hope they're not going into it without the knowledge of understanding about lead paint and all of that. I mean, I'm telling you, if they've gone to the effort of having their place completely de-leaded, that's an awesome positive. That's really, really good. So the pages 28 and 29 talk about what the lead poisoning is about, and this is a serious matter. And again, as Stacy said in the module there in LAER University, that you cannot prevent people from having it tested. On page 31, the tenant certification form, again, talks about the owner's disclosure. And it can be, I would say, 3 different ways. That the owner's never done anything, that he's in the process of having it done, or that he has the de-leading certificate. If you have the de-leading certificate, that's a wonderful thing to put in your paperclip and MLS pin when you're listing that and any other paperwork that they have. And then the tenant is going to acknowledge that they've received all of this paperwork. It's just, there's a lot more responsibility to you as the listing agent to make sure that these forms are all gathered and available to any tenant.
I didn't get one of these with my rental that we just did, and she's an older woman, single woman renting
But
it.
she's represented by an agent.
Yeah.
It's the agent's responsibility. And you could say...
So I have to ask the listing
absolutely.
agent for this. Or send this to him and say, have them.
Yep, and it's in Jostle.
Yeah.
And you can
Okay.
say, my office requires this be on
Okay.
record.
Okay.
And
You said she's an older woman?
Yeah.
So even if it's not somebody under 6, not a family under 6,
no, she's
she
talking...
could have a grandchild, is that it?
No, it's just, no.
It's just a law, right?
She has a buyer for a rental.
Okay.
So the person that listed the rental should have had that lead paint form filled out
Oh.
so that the older woman could declare, I have no knowledge of any lead paint, but it's got to be filled out, and again, filled out by the owner of the home first so that we can acknowledge it, and we have to have that on our records in order to have a complete transaction. So yeah, that's a very good point.
I'm never doing a rental again, by the way.
I actually think we're set. We're pretty set. I mean, this was a lot, and this was heavy stuff to do the first day, but this is a great lead-in for when we go to do the listing documents. We all need the scripts and the understanding of the forms that they're signing, because every time you do it, they're going to ask a different question.
Mm-hmm.
I mean, especially the older people whose homes we're listing, it's so difficult to explain to them. So you're going to explain it in a totally different way than you would a 26-year-old. And they're going to ask questions differently too. But you have to help them to have an understanding of it, because you are there. Remember, always remember Old Car. You know, it's our duty to explain, to represent, to have them have an understanding of it. I remember one time recently, somebody in our company was listing a house for someone who didn't speak English very well, and the person said to the agent, "Oh, I'll just sign anything you want, I trust you." And the agent was like, no, we're not doing that. So, you know, it took a little bit more to explain to them what each of these forms mean. And when you take an older person who's lived in their home 40 or 50 years, they probably signed one piece of paper 50 years ago and a handshake and it was done. So the stuff that our office requires is not any different than what any other office should require by state law to have this stuff on record. And with dot loop, the thoroughness of dot loop is helping us do this more easily. And even if you have to have a person come into the office, you can still use dot loop for that. We'll go over that on Monday.
Okay.
But the lead paint is a serious part of the listing part of it. And then now that if you're showing a house, make sure you look at the paper clips for each. What I usually do is, let's say you're showing 4 houses on a Saturday. If you're pulling the MLS form out anyway to give to them, I would look and see what paper clips were on it so that they could acknowledge those, so that if you end up in Starbucks that afternoon writing the offer, they can fill it out right then and there.
I usually do it the day before I know I'm taking
Yeah,
them. And then I
yeah.
send them the attachments so they can read it, so they have knowledge of the property and what they're looking at.
Yeah.
Good, helps.
So that ends today. Tomorrow we're going to be talking about fair housing and acceptable words and how to put our listings together. So that'll also help lead us into, when we do our listing contracts and everything, this will help prepare us for how to properly represent our sellers. So